Welcome to the USA Immigration Update News.
Tonight's developing situation surrounding U.S. immigration policy is drawing urgent attention coast to coast as new internal documents reveal that the Trump administration is preparing a major tightening of the legal immigration system. This involves a policy proposal that, if enacted, would significantly change how green cards and other immigration benefits are reviewed for individuals from countries included in the expanded travel ban. The scale of this potential shift is substantial, and the implications reach deep into the lives of long-term residents, workers, families, and lawful immigrants across the United States. Before we move forward, make sure to subscribe, like, and share because updates like this will shape major national decisions in the coming months. The draft materials circulating inside U.S. Citizenship and Immigration Services indicate that country-specific factors related directly to the travel ban would be treated as significant negative marks during application review. These internal government documents show that immigration officers would be instructed to consider an applicant's national origin as a major element when evaluating green cards, status extensions, parole requests, and other benefits. That would represent a stark shift away from the long-standing practice of reviewing applicants individually based on personal merit, lawful conduct, and documented eligibility. According to officials familiar with the draft policy, the proposal is still in the final revision stage, but the direction is clear. The administration intends to give USCIS officers far broader discretion when reviewing applicants from countries on the list of expanded travel restrictions. Officers would be guided to weigh nationality as a risk indicator, regardless of whether the individual has lived legally in the United States for years or has previously passed security and background screening. The possible outcomes are significant, especially for those who have established stable lives under lawful immigration status. The countries affected by the expanded travel ban include Afghanistan, Chad, the Republic of Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Myanmar, Somalia, Sudan, and Yemen. These nations face full entry bans under existing policy. The restrictions apply both to new applicants overseas and to individuals seeking to renew visas or adjust their status inside the United States. 7 additional countries, Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela are under partial restrictions preventing certain categories of travel and blocking access to permanent entry. Under the draft proposal, applicants from these regions would face increased scrutiny even when they have complied fully with all U.S. laws. Administration officials argue that the policy is rooted in national security considerations. They cite cases where foreign governments are unable to provide reliable information, making identity verification and document authentication pretty difficult. The administration maintains that stronger measures are necessary to protect the United States from potential security risks and unlawful entry. President Trump stated earlier this year that identity verification issues and inconsistent documentation systems create vulnerabilities that must be addressed. He also referenced data showing higher visa overstay rates among certain national groups, using this as justification for stricter controls on legal immigration. For many families, the impact of these policies is already being felt. Green card renewals, adjustment of status applications, and other immigration filings from individuals in impacted countries have begun facing extended processing times and additional reviews. Under the draft proposal, officers would have new authority to issue denials based primarily on national origin, which could affect thousands of people who have passed every required background check and have maintained legal status for years. The proposal, however, includes exemptions. Those who already hold valid visas or permanent resident cards would be shielded from the new rules. The administration has also made exceptions for athletes traveling to the United States for the 2026 World Cup or the 2028 Olympic Games in Los Angeles. Afghans eligible for the Special Immigrant Visa Program, individuals who provided documented assistance to United States forces during the war, would also be exempt from the proposed changes. According to the draft documents, the policy would apply to immigration benefits that require discretionary evaluation. These include green card applications, certain humanitarian claims, asylum requests, parole decisions, and other case types where officers must weigh positive and negative factors. Citizenship applications would not be included under the proposal. Individuals already on the path from lawful residency to naturalization would not see changes to their eligibility or their review process. Experts who have reviewed the draft materials described the proposal as a significant departure from long-established immigration norms. Analysts warned that applicants could face denials even when they meet every legal requirement, simply due to the conditions of their country of birth. One former USCIS official with senior experience said the proposal marks a major shift in how immigration law is applied. He noted that this would be the first time that challenges with foreign documentation systems are formally categorized as negative discretionary factors. He added that this could lead to outcomes where individuals with strong supporting records are unable to overcome the negative weight assigned to their nationality in the review process. Another former official pointed out that while document verification has always been a challenge with certain countries, previous policies allowed officers to weigh evidence on a case-by-case basis without presuming negative intent or risk. Under the new proposal, however, the presumption of risk is built directly into the review process. This could create a situation where applicants face substantial obstacles even when they have demonstrated compliance, contributed to their communities, and maintained clean records over many years. Immigration analysts note that the long-term impact of the proposal may extend far beyond the countries currently listed under the travel ban. Once precedent is established for treating national origin as a negative factor, future administrations could apply similar policies more broadly. They warned that this could alter the foundation of the U.S. immigration system, which has historically emphasized individual assessment and equal treatment regardless of country of origin. For families inside the United States, the uncertainty surrounding the draft policy is creating pressure and concern. Many individuals from affected countries have lived and worked legally in the U.S. for long periods. They have built stable careers, purchased homes, and raised children who are U.S. citizens. The possibility that renewals or status adjustments could be denied due solely to nationality introduces new instability into their lives. Legal residents who previously expected to progress toward green cards or citizenship now face unclear pathways and unpredictable outcomes. Organizations monitoring immigration policy say they expect legal challenges if the policy becomes official. Advocacy groups are reviewing the draft language for potential conflicts with existing immigration law and constitutional protections. They argue that using nationality as a predefined negative factor may conflict with constitutional principles of equal protection and may face scrutiny in federal courts. Until the administration announces the final version of the policy, the legal community is preparing for multiple scenarios, including litigation, administrative review, and congressional oversight. Despite the concerns, supporters of the draft policy emphasize national security priorities. They argue that incomplete documentation, weak passport controls, and unstable political environments in certain countries create legitimate obstacles for U.S. authorities. They maintain that officers should have broader authority to deny applications when identity verification is uncertain or when national origin correlates with elevated risks. Supporters say the policy would allow USCIS to better protect the country by establishing clearer standards for high-risk cases. As the proposal moves through final review, its announcement could come at any time. Once published, USCIS will likely issue updated operational guidance for officers, outlining how to weigh nationality, documentation challenges, and travel ban criteria during the discretionary review process. The directive would become part of daily practice inside immigration offices nationwide, affecting tens of thousands of cases annually. USA State News will continue monitoring every update coming out of the Department of Homeland Security and the offices responsible for drafting and evaluating this proposal. This developing situation is important for anyone navigating the immigration system, and the consequences will be significant for applicants worldwide. To stay fully informed on every change, every new guideline, and every government announcement, make sure you remain connected with us at all times. Subscribe, like, and share to support this USA Immigration Hub channel.